Good evening, Retamal here, reporting on chapter 6 and 7 of this week readings for the Teach and Share outline. Both of these chapters deal with subjects that are common knowledge to the extent, a very superficial extent, at least from my perspective. I happen to, in the industry that I'm in, happen to deal with in a very superficial manner with some of this terminology, but I had a great opportunity this week to dive a little bit deeper than I would have, um, as this is not something that necessarily pertains to the day to day, yet has an impact on what I do for work. So, contract law basics and defenses of contracts. So I will summarize my understanding of both chapters. Then I will quote one relevant quote from Brother Hales off of the book, establish a connection with somewhat of a real scenario, uh, real life connection between the reading and some of the things that I deal with at work. And I'll probably share one or two takeaways from the reading this week. So, with that, contract law basis provides an overview of the fundamental principles underlying contracts. It covers essential elements such as offer, acceptance, consideration, and the intention to create legal relations. The section also discusses contract formation, capacity requirements, legality, and formalities necessary for a valid contract. Understanding these basics is crucial for parties entering into contracts to ensure their agreements are legally binding and enforceable. Defenses of contracts explore circumstances in which the party may seek to avoid or defend against the enforcement of a contract. This section outlines various defenses, including lack of capacity, misrepresentation, duress, undue influence, unconditionally illegality, and mistake. By recognizing these defenses, parties can protect themselves from entering into contracts under unfair or unlawful conditions or situations where the agreement is not truly consensual or legally sound. One relevant quote, which is the one component that I like to focus on off of the chapter that covers contract law basis from Brother Hale, I quote, Brother Hales, I quote, although not all businesses law books agree, we'll start with the understanding that contracts have just three basic elements: offer, acceptance, and consideration. There's a lot of packed into those few words. The offer is a key component of the contract and consists of the terms and conditions set by one party, known as the offerer, and the presented to the other party, known as the offeree. Acceptance is the agreement of the offeree to the terms of the offer. The final element is consideration. Put simply, consideration is what each party gets in exchange for completing the responsibilities under the agreement. We'll discuss these elements in much more detail as we go along the book. Close quote. Now, where's the connection that I established between that particular quote into the day to day of what I do or my sales professionals encounter? So I'll just read this piece here. Leveraging my professional experience in the service industry as I operate with agreements/contracts in exchange for a service. So In terms of an offer, our company makes an offer to pick up your garbage, Brother Christensen, or whoever is listening to me right now, watching me. Um, we commit to pick up your garbage regularly as a service that we provide to you. Acceptance. You accept the offer by agreeing to pay for a service or otherwise indicating your willingness to engage in this transaction. We ask that you sign a contract or agreement that ranges from 12 months, 1 year to 5 years. Consideration, we will exchange something of value. In this case, you agree to pay the company, my company, for the service, and I agree to pick up your garbage, your waste, or recycling waste. Intention to create legal relations, another component. We are both legally binding in a commercial contract, which includes garbage collection services. Now, let's consider my failure to deliver on the commitment. So we quit showing up, or we sporadically service you not in alignment with what we have agreed upon. The failure to deliver on the commitment to pick up your garbage constitutes a breach of contract, and depending on the severity of the breach and applicable contract law principles, you may have the right to terminate a contract, which is typically what what happens. That's the actual application of a breach. Now we are the number one in the industry. We're not perfect. We have a 99.9% accuracy in our services, but we're not perfect. So as an added note and a special plug, we don't get fired every day of the week. It doesn't happen very often. But seldom we fail to serve, and customers can exercise um, their prerogative. Okay, so that's how I interpreted the reading this week, and that's how I saw and made the connection between my readings and the day to day of my work. Personal takeaways. One key takeaway from the elements of a contract is the importance of mutual agreement and understanding between parties, as evidenced by the offer and acceptance. In addition, considerations highlights the necessity for both parties to exchange something of value for the contract to be enforceable, emphasizing the principle of reciprocity in contractual relationships. Consideration was one of the I guess understood parts or components of elements in a contract that I really didn't know the book definition of it. So I uh, exchanging something of value. I get something for something. I give something and I get something in exchange in return. So um, very practical information. Um, it gave me once again, just like in weeks past, more it elevated my level of education when it comes to um, business law and how it applies to the day to day of running the business, and how we can more effectively communicate with peers alike, competitors, and customers.